All right, we're going to get started. Hi, everybody. My name is Alex Friedland. I'm the director of the Janus Forum. Before we get started, I'll introduce the speakers and we'll get going. But first, I've got a few thank yous. First, I want to thank the Political Theory Project, our sponsoring organization, John Tomasi, Dina Eggy, Mary Mossid, and Stephen Calabresi, professor here, who really helps with the Constitution Day events. Obviously, it's right up his alley. Then I want to thank the Janus Forum. They put a lot of work into organizing this event, advertising for it, and so we're really happy to have it. And finally, I want to thank all of you for coming out. I know it's hard. It's a Wednesday, middle of the week, a lot going on, career fair, but we're really happy to have you, and hopefully this is going to be a great event. If you're interested in learning more about Janus events in the future, just like our Facebook page or visit our website, www.janusforum.org, and we'll be posting all our events. There's so much going on in the world right now that we're trying to make our events topical, so we won't be announcing our November and December events for another few weeks, but keep an eye out. So I'll introduce our speakers, and then they will each get about 20 minutes to speak, and then we'll go into a Q&A, which will last about 45 minutes, and then we'll wrap it up. So our speakers today, Lawrence Lessig. He's the Roy L. Furman Professor of Law and Leadership at Harvard Law School. He is the director of the Edmund J. Safra Center for Ethics at Harvard, and he founded the Mayday PAC, which is a crowd-funded super PAC. It contributes funds to candidates to Congress who claim that they're going to try and pass campaign finance reform. Then we have Professor Eugene Volokh of UCLA Law School. In addition to writing a bunch of textbooks and law reviews, he's the editor of the Volokh Conspiracy, which is one of the most popular law blogs in the world, with about 25,000 unique visitors per weekday, which is a lot for a law blog. So, without further ado, we'll get started. Lawrence Lessig.
Great, so it's wonderful to be back, and it's a great pleasure to be here with Eugene. I was in a debate like this, I think it's 4 years ago with Brad Smith, and this will be a much more difficult debate, I guarantee you, because Eugene is certainly one of the Legal Academy's greatest minds, scary, great minds. So I've got to start by deflecting a bit. And I want to deflect with two conceptual points about how we should understand something central in the context of this debate. The first is about the role of the word corruption in the debate about campaign finance reform. Corruption has a kind of magical power, at least in the courts, because it takes an otherwise pretty firm prohibition that Congress shall make no law abridging the freedom of speech, and it says, but if the speech is deemed to be corruption, then Congress is free to abridge away. So what that means is what corruption means becomes a very important question in deciding the scope of legitimate regulation in the context of campaign finance reform. And the Supreme Court has looked at this in inconsistent ways over the past 40 years. But if we think about it, we can understand corruption, I think, clearly if we think about it as a certain kind of influence that might be applied to members of the government, to Congress, or that might be applied to the people. And what the court has been pretty clear about is that Congress can regulate what it calls quid pro quo corruption. But quid pro quo corruption is, of course, not against the institution of Congress. Quid pro quo corruption is the sort of thing that individuals within the institution engage in. A congressman saying, I will get this legislation passed if you give me $50,000. So it's an influence within this economy of influence that members of Congress live within that is corruption when it steers members away from a focus, the focus they're supposed to have on their constituents. And it is corrupting then at the level of the individual because it undermines this representative function. Now, since 1976, in the case of Buckley versus Vallejo, the Supreme Court has said that speech that regulates corruption in that sense is fine. Quid pro quo corruption is regulable because it's important to the integrity of the political process. But that leaves open the question, of this influence that might be said to be corrupting the people. And that issue got framed very sharply from a case that grew out of a battle in the state of Michigan. In Michigan, the view of the politicians, at least, was that corporations were too influential in political battles. So there was a move to limit the corporation's power to speak. And the move to limit it, therefore, was not a move to limit or control the way somebody was affecting a governmental actor. It was a move instead to regulate the way in which somebody was influencing the people. And in this case, Austin versus Michigan, the Supreme Court said that was perfectly fine. The court said the corrosive and distorting effects of immense aggregations of wealth accumulated with the help of the corporate form with little or no correlation to the public support for the corporation's political ideals was a, quote, different type of corruption. That corruption, the court said, distorts the political process. But it's important to focus on what it was distorting. Because what the court was not saying was that it was distorting the legislators. The court was saying it was distorting the public. The people were being distorted by this speech from corporations. It was a corruption of us because of this unequal money. And the remedy was to equalize, in some sense, the influence so that we, the people, would not be distorted by this speech. Now, in the case of Citizens United versus the FEC, the court made it very clear that the earlier decision of the court notwithstanding, that kind of influence was not, quote unquote, corruption. That we, the people, could not, in this sense, be corrupted. That, in some sense, if there's a distortion, the court can't see the distortion, or at least, according to the court, the state can't remedy that kind of distortion. That we, the people, in a sense, are on our own. We have to listen to speech and protect ourselves from any distorting effect. We have to take care of ourselves, and the government could be no guardian of equality in the context of that kind of speech. Now, it's going to surprise you and upset some of you, I guess, and maybe make the exchange between Eugene and I a little bit more interesting when I say to you that I think the Supreme Court was right in that respect. I think the Supreme Court was right in Citizens United to say that it's not the concern of the government to worry about how somebody's speech affects the public. That inequality in speech is not, quote, corruption. That distortion of speech is not, quote, corruption. It would be if we embraced the norms that governed at the time of Demosthenes. Remember, Demosthenes was forced to speak with pebbles in his mouth because he was such a persuasive, rhetorical speaker. That was the only way to make it fair, to make him mumble when otherwise he could so powerfully persuade. But the United States is not Greece, at least yet. So we have to distinguish, I think pretty importantly, between the kind of influence that is properly deemed to be corruption, influence of government officials, and the kind of influence which is not properly deemed to be corruption, influence of the people. Okay, that's the first conceptual point. Here's the second. It's taken for granted, of course, in the United States that campaigns are privately funded. But as that private funding system has evolved, it has become quite different from what it was even just 20 years ago. Because now, members of Congress and candidates for Congress spend anywhere between 30% and 70% of their time raising money to get back in power or to get their party back in power. Huffington Post leaked this memo from Michelle Nunn's campaign where she was told she had to spend 80% of her time raising money, except in October, where she was told she was allowed to spend only 50% of her time raising money. Now, the thing to think about is what does it do to these members and candidates as they spend their time dialing for dollars, speaking to these people across the country? What they do, obviously, is they learn what they must say in order to succeed in their task to raise money. So B.F. Skinner gave this image of the Skinner box where any stupid animal could learn which buttons it needed to push in order to get the sustenance it needs. This is the picture of a modern American congressperson. As the congressperson learns which buttons he or she must push to get the sustenance his or her campaign needs. Now, as they do this, They develop, as any of us would, a sixth sense, a constant awareness about how what they do will affect their ability to raise money. They become, in the words of the X-Files, shapeshifters, as they constantly adjust their views in light of what they know will help them to raise money, not on issues 1 to 10, but issues 11 to 1,000. Leslie Byrne, a Democrat from Virginia, describes that when she went to Congress, she was told by a colleague, quote, always lean to the green. And to clarify, she went on, he was not an environmentalist. So the point is we have this institution that is dependent, but dependent upon the funders. And that dependency should trigger a certain kind of constitutional worry. Because the framers of our Constitution, they didn't give us a democracy, they gave us what they called a republic. But by a republic, they meant a representative democracy, and by a representative democracy, they described in Federalist 52 a government that would have a branch that would be, quote, dependent on the people alone. And Madison was pretty clear about who the people were. Of course, they didn't include women, and they didn't include African Americans, but in Federalist 57, he made clear that the people meant not the rich more than the poor. They were wealth egalitarians when it came to citizenship. And that was the conception of representative democracy they were establishing. So this was their model of government, at least with respect to the representative branch. They had the people and the government. I do my own slides. It's cool the way that bounces. I can show you how to do that. It's dramatic. This exclusive dependency that would produce a certain reflective way in which the government was to function. But the problem is, of course, Congress has developed a different dependence, not a dependence on the people alone, but a dependence increasingly on the funders. So who are they, these funders? Well, if you think about the relevant funders of campaigns, the people who give enough to make it sensible for candidates to care about what they think, the number of relevant funders of campaigns in America right now is about 0.05% of America. 0.05% are the people who are being called. So at most, about 150,000 Americans, which the internet tells me is about the same number of people as are named Lester, which is why I called the United States Lesterland at a TED Talk. And after the Supreme Court's decision in McCutcheon, I think that number will fall to no more than 35,000 Americans, which turns out to be the same number of people as are named Sheldon, according to this wonderful website. And if we think about the influence created by the DC Circuit's case Speech Now, the influence created by the super PAC, that number is even smaller. So in 2012, my favorite statistic was 0.000042%, which for the math whizzes in the audience, you know means 132 Americans. 132 Americans contributed 60% of the super PAC money that was spent in that election cycle, which is about the same number of people as named Adolf. Okay, so whether it's Lesterland or Sheldon City or Adolphia, the point is we've developed a government that is dependent not on the many but on the few, which means precisely we have developed a government which is not dependent on the people alone. Now, in a very ordinary sense of the word, that is a corruption of the design the framers gave us. It's a corruption of the original design, a corruption predicated not of the individuals, it's a corruption predicated of the institution. No one needs to say that anybody inside that institution engages in bribery in order to say that the institution is not dependent in the way the framers intended it to be dependent. It has been corrupted by another influence being added. Okay, those are the two conceptual points. And then here's the argument about what we should do that might set up what I hope to be the difference between Eugene and I. Okay. It seems to me if that's the description of a problem, a dependence which has corrupted a design of an institution intended to be dependent on the people alone, the analytics are easy for how you would fix it. You would fix it not by going around telling people they can't speak, not by rules that stop them from trying to influence the public. You would fix it by focusing on the corrupting dependence as it relates to government officials. So if the problem is they're spending tons of time fundraising from too tiny a slice of America, the solution is for them to spend less time fundraising, but from a wider slice of America, to spread out the funders' influence. And to do this, what you would do is what we did historically with respect to the franchise called the vote, we gave everyone the franchise. It started very narrowly granted to just white male property owners, and over time we expanded it broadly. But here it's not the voting franchise that we need to worry about, it's the funding franchise. We need to expand the funding franchise to make everyone in this sense a relevant funder. And to do this does not require any amendment of the Constitution. A single statute, which would, I'm going to push a particular version, but there are a couple different versions, produce vouchers inside of the political system to help candidates fund their campaigns. Now, this is an idea that's been around for a long time. Rick Hasen described it in the mid-1990s. Bruce Ackerman and Ian Ayres have a wonderful book about this idea, voting for dollars. In my book, Republic Lost, I mix these ideas together a bit to create a stronger incentive. I describe what I call the Grant and Franklin Project. The Grant and Franklin Project begins with an assumption. The assumption is that all of us contribute, quote unquote, at least $50 to the federal treasury. Not necessarily through income tax, but through some tax. We all send at least $50 to the federal treasury. So the Grant and Franklin Project says, okay, let's rebate that $50 in the form of a voucher. So we all get the first $50 back in the form of a voucher. And we can give that or some portion of it to any candidate if that candidate agrees to limit the contributions he or she takes to the vouchers plus contributions of up to $100. So Grant, $50, Franklin, $100. Now, $50 a voter, forget the $100 that they could take, works out to be about $7 billion, which means that's about 3 times or 2.5 times the total amount spent in congressional elections in 2010. So this is real money, but it would be real money coming from a wide range of Americans. These vouchers would support candidates without them being dependent on such a tiny, tiny slice of America. Now, support for vouchers in this sense comes from both sides of the political spectrum. So Ian and Bruce are no conservatives. But this guy, Richard Painter from University of Minnesota Law School, who was George Bush's chief ethics officer, has proposed a much more ambitious voucher program, a $200 voucher program, under the frame no taxation without representation, because his argument is, under this system, we are not represented, it's the funders who are represented, and so therefore under this system we should not be taxed, and we can only be taxed when we are represented, and he says vouchers are the only way to get him represented. So vouchers here are a kind of vote, it's a franchise of the citizens in this critical first stage of the elections. Now, you look at this, but vouchers are different. Vouchers are money, and the money is being given to us by the state. Votes are not money. But now you need to embrace your inner Tea Party for a second, because the question is, whose money is it that we are getting from the rebate from the government? Right? It is our money that is being rebated to us from the government in the context of such a voucher. So if the vote is democratic power returned to all of us in the context of a representative democracy, the voucher is democratic power rebated to us to enable us to participate equally in the context of funding for the elections that we are subject to. So that's the analytics. I think the analytics are easy here to remove us from Lesterland, which we need to get out of constitutionally. Okay, but then you can say, well, what about super PACs? The first important point to recognize is that the Supreme Court didn't create super PACs directly. The Supreme Court is not directly responsible for super PACs. Citizens United said that the expenditures of corporations and unions could not be limited if spent independently of a political campaign. But the DC Circuit, in this case, Speech Now, said that follows then that contributions can't be limited if you're contributing to an independent political action committee. But I'm sure you can see the difference. Expenditures, contributions, right? Those are 2 different words, right? You get that? Expenditures, contributions. And the question is, does it follow that just because expenditures can't be limited, contributions can't be limited? And I think the answer is it does not follow that the 2 can't be limited. Because, of course, the super PAC is doing 2 things. One thing the super PAC is doing is speaking to the people. And in that sense, I absolutely agree with the court. There's nothing for the government to do to try to restrict the ability of the super PAC to spend its money to influence the people. But the other dynamic is the way the super PAC is influencing politicians. And here we have to listen to the politicians talk to us about what the dynamic of super PACs have produced. There's a super PAC dynamic here which evokes the image of Tony Soprano more than the image of James Madison. And this was explained to me most powerfully by Evan Bayh at a conference, at an event I was participating in, where he was asked by the late Senator Arlen Specter to describe what super PACs had done to Washington. And he said, you know, the biggest problem that we face, that we think about as an incumbent, is that 30 days before an election, some super PAC is going to come in and drop $1 million on the other side. So what do? Well, what you do is, as a politician, you try to buy super PAC insurance. Those weren't precisely his words, but that's what he was saying, insurance. Insurance so that if somebody comes in and drops $1 million against you, you have somebody who can drop $1 million for you. All right, so how do you buy insurance? You're all old enough to recognize that if you're going to get insurance, you're going to have to pay your premium in advance. We'd love to help you, Senator, but we can only support people who support us at 80% voting records. So the point is, as you, as a senator, recognize, this was Bayh's argument, what you need to do in order to assure the protection you know you will need, without $1 being spent by the super PAC, you have secured the loyalty of the people on your particular side of the debate. And the point is then, that influence is an influence that is being applied to members, not the influence that might be applied to the people. It's the economics of a protection racket. And what it's doing is increasing the dependence that already exists because of the way campaigns are funded on the Lesters, the Sheldons, the Adolphs, depending on your focus, and therefore increasing the quote-unquote corruption of the current system. A corruption because not of the influence that might be influencing the people, but because of the influence on government officials, precisely the thing that the court has said we ought to have the power to protect against. Okay, so therefore, here's the punch. My view, Congress can limit contributions to independent political action committees, even if they cannot and should not be able to limit expenditures of independent political action committees. And so I would say we should be resolved in our dealing with the, quote, problem of campaign finance reform, or what I call the problem of corruption, by number one, changing how we fund elections, changing the way we fund campaigns. I would endorse a voucher model, but the ideas of matching funds that John Sarbanes have pushed in his bill, the Government by the People Act, are equivalent. They are about increasing the number of people funding campaigns. Number two, the court should reverse speech now. The court should say there's nothing wrong with appropriate limits on contributions to the extent you can show those contributions are corrupting the dynamic of representation, which, in the sense that I've described corruption, I think they plainly are. And number three, we should be watching the ongoing effects of Citizens United and Buckley. Because the thing to recognize about those two decisions is how little they mattered directly. After Buckley, everybody thought the rich people are going to spend all their money to control elections. And some did, the Soroses or the T. Boone Pickens. But the point is, most rich people were shy. They didn't like to be out there kind of asserting themselves with their money directly. And after Citizens United, everybody said, and I was one of these people, corporations are going to spend all their money influencing elections. But very quickly, corporations discovered the high cost of free speech. Target, for example, supported an anti-gay candidate running for governor in Minnesota and quickly found their stores picketed across the country. So corporations, too, don't actually like much to engage strongly and openly in the context of the political speech. The real place in which there has been a change is in the indirection facilitated by super PACs, where, because of one or two layers of insecurity, it's possible for the corporations or rich people to have their influence without bearing full responsibility, even with perfect transparency. So, in my view, we should think about, in the context of the First Amendment, Citizens United speech or Buckley speech as not really pleasant or wonderful to the extent that what it's doing is allowing this powerful impact that might overwhelm an impact of many, many more people. It's not that I would say it's wonderful speech, and I'm sure here's a place where we'll have some disagreement, but I see it more like the freedom that the Nazis have to march in Skokie. Like, you can despise what they're doing, but recognize that a robust system of free speech requires that they be able to do that. And I think a robust system of free speech might say we should tolerate this individual freedom because systematically it actually isn't mattering that much. What is mattering is the additional step taken by the DC Circuit to allow the beginning of super PACs. So that's my position. Thanks very much.
And now, Professor Eugene Volokh.
Oh, all right. That should be easy enough. And I'm sorry, the clicker. Did I put it in my pocket? Oh, well, that's all right. Oh, never mind. Technology, too complicated. Good afternoon. It is such a great pleasure to be here. Partly because actually I hadn't realized until I saw the massive bear statue, that the symbol of Brown is the bear, and that's of course UCLA's symbol too. The Bruin just means brown bear, so I feel this kinship. Surfing's better over on my end of the country, but other than that, it's a great pleasure to be here at Brown, but it's especially a great pleasure to be here talking about this with Larry. Larry and I, as he pointed out, go way back as co-authors, and I've long admired his work, and in particular, I've long admired his ability to present things both clearly and I think eminently fairly, and there's very, very much in what Larry said that I agree with. In fact, you know, I think I'd like you to think about this more as a discussion than a debate. I think there's much that we agree with. There's some we disagree with, disagree on. But I'm hoping, in any event, what you'll hear from me and from Larry are different enough in focus that you'll find this helpful and useful. Taking a cue from Larry, I actually just updated my PowerPoints just as he was speaking. I wanted to start out by pointing out a conceptual distinction, which is really important. And I think Larry will agree with me that it's really important. If you read Buckley, if you read Citizens United, you read any of these cases, you read news coverage on the subject, which often misses this distinction, as a result completely botches things. It's between contributions to candidates and expenditures independent of candidates. Here's what Buckley v. Vallejo more or less said. It turns out I'm probably one of the very, very few law professors in the country who actually thinks it got this particular thing right. It said, look, if you want to give money directly to a candidate, that can be restricted. But if you want to spend money independently of a candidate, that is protected. So if, for example, you give, the cap there was $1,000. If you give $1,001 to a candidate, that could be made a crime. But in part of the reason, as I read the opinion, part of the reason why it could be is it doesn't really burden your ability to speak or to associate with others for purposes of speech that much, because you're still free to spend that money on something else. One of the things that the court majority, and by the way it was a 7-1 decision, Buckley, was that the majority pointed out is under the statute, which banned both contributions and independent expenditures, it would be a crime for someone to go and buy an ad in a newspaper. At least a sufficiently high circulation newspaper, expressing their support or opposition to a particular candidate. If you want to buy an ad saying, let's say, Rand Paul is running in 2016, Rand Paul is awful for the following reasons, and you spend more than $1,000, which you kind of have to in order for the ad to reach anybody, at least in traditional media, that would be a crime. And the court said, well, that can't be done. So it's important to realize that today, actually, contributions by individuals can be and are capped. It's not $1,000, I think it's $2,600 now. Contributions by corporations and unions are actually completely forbidden. But independent expenditures by individuals, corporations, unions, and others, that is what's constitutionally protected. Note an important distinction. It sometimes is drawn, the line is drawn or described as contributions versus expenditures. But what it really is about is whether it's to the candidate or independent of the candidates. What speech now said is, look, if you have the right to spend your own money independently of a candidate, if you have the right to spend $10,000 or $1 million independently of a candidate to say, I independently want to say that this is a bad candidate or this is a good candidate. Or for that matter, if you have the right to spend $100 million to buy a magazine, which will then editorialize for or against candidates, you have the right to pool that money with other people. That's part of your right of expressive association, a right that has been recognized in a line of cases, starting with cases involving the NAACP, for example, in the 1950s. The theory was for many people, in order to be able to effectively speak, they have to be able to pool their money. So what speech now says, and I do think correctly, is that expenditures independent of candidates includes expenditures where people pool their resources independently of the candidates. What it doesn't include, however, is contributions directly to candidates, whether by one person or by a group of people. Those are much more restrictable. So that's an important conceptual point. You might or might not agree that it should make a difference. There are some who oppose the Buckley line from the left, saying, or at least what is today the left, Buckley at the time was quite a bipartisan, bi-wing decision, who say, look, contributions and expenditures should both be equally restrictable. There are others who oppose it from the right, say contributions and expenditures should be equally protectable. But the important thing to realize is usually when contribution expenditure line is drawn, not quite where Larry's drawing it, it's certainly legitimate to try to draw it in a different place, but usually when you hear from courts lines about contributions versus expenditures, it's contributions to a candidate versus expenditures independent of a candidate, and it's considered okay to restrict contributions to candidates in large part precisely because expenditures are a way of effectively speaking otherwise. Now, many of you might say, well, what's this about speech? This is about money, and money isn't speech. I've heard this very often. Money isn't speech. And I will tell you right now personally, money isn't speech. I agree 100% that money isn't speech. But let's imagine a law, and you can imagine the states which might want to pass such a law if they could, which says no person or group may spend more than $100 on abortion. You can't spend your money to get an abortion for yourself or a family member. You can't spend money to donate to Planned Parenthood so that it can get abortions for anybody else. And they would say, this is not a restriction on abortions. This is a restriction on money. Is money abortion? No, money is not an abortion. Therefore, it's okay to restrict it. I think we sort of scratch our head and say, well, that can't be right. Why can't it be right? Because after all, in order to do anything in a free society, you have to use people's labor in one way or another and use people's assets in one way or the other. The customary way we do that is by paying for them. You could imagine an organization in which there are abortions provided by volunteer doctors using the provision of instruments that are lent to them by organizations that want to do that. As it happens under some election laws, you can imagine even that would be treated as expenditure because all those things have money. But you can imagine that would be a very poor way of trying to provide abortion services to the public. The customary way is hiring people and paying them a salary to do that. That costs money. If you interfere with the spending of money for the exercise of abortion rights, you are burdening abortion rights. What if you were to say no person or group may spend more than $100 a year on contraceptives? Likewise, that's unconstitutional, not because money is a condom. It's unconstitutional because restricting the spending of money on exercise of a right is a burden on the exercise of a right. Now, this might seem quite transparently just attempts to interfere with abortion or contraceptive rights, because we don't have the corruption or equality dimension that is often present in a lot of such arguments. But sometimes you do have equality arguments. What if somebody were to say, look, we just think it's unfair that there's some churches that have this outsized power, including political power, because they're very well funded. So you can't spend more than some amount of money on supporting religious worship. Or how about private education? How many people here went to private schools, at least part of their education? Right. And I think that's wonderful. And you probably got a better education than at public schools. And the reason I think so is because I think your parents weren't dumb. If you had gotten the same education, they wouldn't have spent all that money on your private education. I believe in revealed preferences and the wisdom of crowds in this respect. You got a better education, but that means you got a better education than people who are poor and couldn't afford that. I don't want you to feel guilty because of that. That's the reality of life. Maybe we'd prefer a system in which public education were so wonderful nobody would want to send their kids to private schools. That's not the system we have. And the Supreme Court has held, I think quite correctly, that there is a constitutional right to buy your own private education. But it without doubt has equality effects. There's no question in my mind that the availability of private education exacerbates to a certain extent income inequalities. It allows rich people to make sure that their kids are going to be rich too. I don't think that's inherently wrong. Egalitarians might. If they were to say that in order to fight this, you can't spend more than $1,000 on private education, I think we'd say that's unconstitutional. Or, another form of inequality, O.J. Simpson can afford the dream team, typical criminal defendant can't afford much. Many public defenders really are very good, but they probably aren't as good as something that somebody pays hundreds of thousands or millions of dollars to buy. Or to buy the services of, excuse me. But of course, I take it we would agree that this restriction on spending of money for private lawyering is an unconstitutional burden on your right to have a lawyer, even though, again, money is not assistance of counsel. So money is not any of these things, and it's not speech. But restrictions on spending money on the exercise of a right are restrictions on that right. Restrictions on spending money to speak are restrictions on speech. I think Larry and I agree on that, but many people don't. And I thought it would be worthwhile to respond to those arguments because they're among the most common arguments you hear in debate. Now, another argument that people make is about disproportionate access. Say, well, if somebody calls up a senator and he's a donor, isn't he going to get more access to the senator? More likely the senator will take his call. The answer is yes, and that's true even if the person is not a donor but an independent spender. By the way, I think, at least as to Adolf Land and maybe as to some of the others, the statistics that Larry gave include independent expenditures, which I think he would allow to continue even if, so long as they're not coordinated with other people and not just contributions. But whether it's contributions or independent expenditures, senator knows who's spending money or who spent money last time or who hopes will spend money next time trying to support or oppose him, and he's going to know that when deciding whether to take a call. I think that's a very serious problem. But the question is, what is it legitimate to do about this? So imagine that the staffer says, Senator Smith, the newspaper publisher is on the line. Remember newspapers? People used to read them, they're like on dead trees. Well, they used to be very important. Today, there are other things that are important. If we looked back in 1900 and looked not at the amount of money spent on a political campaign, but tried to in some measure quantify, and we probably could do that, try to in some measure quantify the amount of influence that everybody had, we would probably say that 0.000042% of the population had this disproportionate influence. They would be the local newspaper publishers, because they're the ones who get to control what is said in the editorial pages and who is endorsed, and more importantly than who is endorsed, how the coverage is slanted, which is something newspapers are constitutionally perfectly free to do. And magazines, in fact, not only constitutionally but customarily do. Newspapers, we have this notion they ought to be impartial. It's a relatively recent phenomenon. Magazines, everybody understands, often have a party line, and that makes their publishers very important people. What if Ben Affleck is on the line? Very nice guy. His daughter was in a spelling bee that my wife and I put together. Nothing against him. I know he's a big, he endorsed President Obama. You know, if he calls up, maybe not President Obama, but calls up a local congressman, the congressman might say, well, that's a call I should take. Maybe if it's a congressman in Hollywood, he'd say, oh, really, Ben Affleck? Well, I have 100 other A-list celebrities on my Rolodex. But if you are a celebrity in a non-celebrity heavy district, your call is going to be taken. Is that fair? Not quite. But what do we do about it? Likewise, what if the head of the Sierra Club is on the line? What are the union leaders on the line? All those calls are going to be taken. Is it fair? Probably not terribly fair. But if somebody were to say, because of that, the newspaper publishers ought not be free to endorse candidates. They ought not be free to slant their coverage in favor of candidates. Celebrities, whoever happens to be, it could be a movie star, could be sports figures, anybody else who can grab the public attention and whose endorsement might be trumpeted in order to bring in votes, or just might make a news story. If we were to say that they can't endorse candidates because it's unfair, why should Ben Affleck have more of an influence on an election than I would? Or likewise with the heads of advocacy groups or union leaders. Incidentally, the senator will take their calls whether or not they're talking about kind of public-spirited things, or maybe the newspaper publisher has a side business. He owns the newspaper, he also owns the local factory, and he wants to talk to the senator about some regulations that deal with the factory. That's possible, but we don't restrict the rights of newspapers to speak or celebrities or others to speak, just in order to prevent that pretty serious harm. It's something that I do not deny as a harm. So I think neither unequal access nor the danger of corruption in the sense of an implicit bribe, not explicit, those are criminal, but an implicit bribe, I think those are present in all of these situations. I just think they help illustrate that that's not reason enough to restrict people's ability to speak. And one way of thinking about it, Michael McConnell, who is also another First Amendment law professor, who has written recently on the subject, says maybe the right way of thinking about campaign independent expenditures is about not through the lens of the free speech clause, but the free press clause. Look, a magazine is free to editorialize all the time, and they do that. They do that, again, both explicitly and much more important, subtly. Magazine can slant stories all the time. A buyer of an ad wants the ability to do the same thing. Whoever owns the New Republic has a lot of influence. Somebody else says, look, I could go out there and buy the New Republic, but I'm not that rich or that foolish with my spending of my money. Political magazines are not exactly wise investments in many ways, but I do want to convey my views. I just want to buy an ad, if not in the New Republic, somewhere else. I want to be a publisher for a day. Now, some people, for example, Justice Stevens and the other dissenters in Citizens United, of course says, well, but corporations aren't people. By the way, another thing, money isn't speech. Corporations aren't people. Not in any lay sense of the word people. I'm happy to admit they aren't people. But New York Times is published by a corporation. ACLU is organized as a corporation. Sierra Club is organized as a corporation. Take it, we wouldn't say it's okay to restrict their speech simply because they're organized as corporations. And I assume this is because we recognize that burdens on the speech of corporations are burdens on the speech of people, actual human people. And that's true as to the burdens of the speech of people, but also the burdens on people who might want to hear what they have to say, but might not be able to hear it if the ACLU or the Sierra Club or New York Times or Citizens United or some other corporation were told you can't spend your money. So as I said, think about it through the lens of freedom of the press. Of course, one possible answer is, well, look, they aren't the press. Once you buy a magazine, even if you spend filthy lucre to do it, even if it's unegalitarian, even if you run it as a corporation, well, then you are the press, because you're in a business sector called the press. But other people who don't buy magazines, who just want to rent space in magazines or newspapers or on TV stations, they're not the press, they're just people. They only have the reduced free speech rights, whereas the magazine publishers have free press rights, which are broader, which include the right to editorialize about candidates, slant stories, and the like. But there's an alternative vision of freedom of the press, which is freedom of the press, a thing, a big piece of metal at the time. These days, maybe this itself, in a sense, is a press, or at least the website I use to publish my blog, which of course used to be independent and now in the Washington Post. Maybe that doesn't make a difference whether I am to be treated as a member of the press and industry, whether Larry is a member of the press as an industry. Maybe the freedom of the press is the right of all to use the printing press and its technological heirs. And if that's so, then I do think that the freedom of the press includes the right to rent space in somebody else's medium and to say, today I want to be talking. Now, let me just close with one point that I do think Larry and I disagree on, and maybe one point that I think we might agree on, although it's an interesting question. So I think that the voucher plan that Larry outlines, I think it's a very interesting idea. I think there are, as with anything in politics, anything in life really, but anything in politics, things don't come out exactly the way you plan because other people plan around it. My sense, for example, is if we have these vouchers, what would happen is there would be a lot more candidates springing up just to use that, not to win elections, but to spread their views. So for example, I know a lot of people in gun rights circles, and I'm sure they would be delighted to say, okay, I'm going to run a candidate in some, even for president, who's just on the gun rights party platform. Am I going to get elected? I won't get elected. That's okay, because it's not like we have to spend a lot of money in this. We will just have all the people who feel very, very strongly about that contribute to this candidate through these vouchers. It's no loss to them, except the loss of the opportunity to contribute to others, which may not matter that much. And all we'll be doing is buying ads about the importance of gun rights. That may be wonderful, actually. Maybe we should have more such issue advocacy rather than just personal advocacy about the qualities or foibles of people in elections. But that's the kind of thing you might want to think about. But I do think it's a very interesting experiment. I would love to see it tried out at the state and local level. There have been attempts at public financing in some places, of course. The results are controversial. It would be an interesting thing to try out in a state, especially one that is inclined already to such experiments, as many are. The one thing I disagree with is returning to the point that I started with on the first slide. As I understand Larry's point, and I'd be happy if I'm mistaken to be corrected, Larry's point is that people have the right to spend money, but only their own money by themselves. So it's not just that they can't contribute unlimited sums to a candidate. On that point, we agree, and of course, the Supreme Court agrees too. But they can't pool their resources with somebody else. Sheldon Adelson can take all of his own money and spend it on something, or not all of his money, but a pot of money which all comes from him. George Soros can do that. But if a bunch of people want to pool their own money and each one contributes enough, as I understand it, that's impermissible. So maybe if a whole bunch of people contribute $100 each, maybe that's permissible. If one person contributes 10 million, that's permissible. But if a bunch of people want to contribute a couple of tens of thousands or something, that is impermissible. I'd love to hear more about that. Maybe that is a sensible result. I do think that poses very serious constitutional problems. I think a lot of important political movements throughout American history have been funded by people who spend their own money. I think the abolitionist movement is a classic example, but there are many others, and environmentalist movement and such, by people who spend their own money in order to spread their ideas. Usually, it makes lots of sense for them to pool their resources this way, because rather than having one set of ads running from one person, another from another, and none sort of really reaching enough people, you could have them organize think tanks, organize advocacy groups, join together. Why are the NAACP, the ACLU, the NRA, the Sierra Club powerful? Because they pool resources from lots of people. Many small donors, but also large donors. That's true with regard to their advocacy about public issues. I think it ought to be true with regard to the advocacy about candidates and ballot measures as well. But I'd be happy to discuss this further.
Okay, now we'll move on to the question and answer portion. So we have microphones set up on either side. I just want to remind people, keep our questions short. Personal anecdotes are discouraged. Okay. Go ahead.
Okay, hi, my name is Nancy Kalick. I teach here in the Department of Religious Studies. I had a brief comment. It's not an anecdote, but if you went to public school, don't feel you're at a disadvantage. I went to public school and I teach here now, so don't worry about it. You're here, you'll be fine. But the question is actually just about the issue of the quid pro quo, which I felt dropped out of your comments. Dr. Volokh, I wonder if you could talk a little bit about that, because the analogy with access from celebrities or publishers, I'm not entirely sure the quid pro quo argument is sufficiently addressed there. I'm not sure what a congressperson could do for Ben Affleck, whereas the issue of access and quid pro quo when it comes to corporate interests, I think is a larger one, and I wondered if you could address that a little bit.
Sure. One thing that I think Larry and I will agree on is I'm not a doctor. I appreciate this, but in our branch of law, branch of the academy, they actually let us go teach without a real doctorate. So you can call me professor, you can call me Eugene, but I can't claim credit for a PhD. Let's say that the newspaper publisher calls up the senator and says, you know, that bill that's being proposed, I think it's a really bad bill. I just want to let you know. The senator says, well, that's interesting. He didn't say, or else I'll editorialize against you, or else I'll make you look like a fool in every story I write, or for that matter, in every photograph of you that I run, I'll just make sure you get photographed like this. But it's kind of implied potentially. Now, if the bill is a gun control bill, let's say, for or against, then you could say, well, that's just the person talking about something that he has just a purely public interest in. Although even there, query whether that might be a quid pro quo. You can still bribe somebody it's still illegal to bribe somebody outright in order to get them to vote on something even if you're just public interested. But you know, the publisher of a newspaper is first and foremost a businessman, and a newspaper is a business. Maybe the bill has to do with antitrust laws applied to newspapers. Maybe the bill has to do with libel law. But more to the point, especially these days, the owner, actually probably at any time, newspapers are pretty expensive to run. Who runs them? Very often it's people who have other business interests. And there's a risk of corruption there as well. Just like we may worry about if Sheldon Adelson calls somebody up, maybe what he wants is some better treatment for his casinos. Maybe the newspaper publisher wants better treatment for his newspaper, or maybe he also owns a casino. What about Ben Affleck? Ben Affleck's a businessman. Entertainment is a business. Arnold Schwarzenegger in his day, before he became a politician, was not just an actor, he was apparently a very successful real estate investor. Unions, obviously, the union leader might want better treatment for his union, which you might say is public-spirited because he's helping workers, it's also helping him. And it may, in some respects, help him more than his workers. So I think the risk of corruption is present in all of these situations. Whenever you have a situation where somebody is spending money in order to speak out in favor or against a candidate, there is always the risk that the candidate, knowing that, is going to say, what do I give this person in order for him to spend in my favor or against? And I think that's a danger, whether it is a media-owned business owner, whether it is a celebrity who has, again, his own professional and business interests, or whether it's the owner of a non-media business who has his own non-media business interests.
So can I just emphasize something to make sure that a distinction between what we're arguing is clear? The structure of Eugene's argument is to show that there's inequality everywhere. And I agree there's inequality everywhere. And I'm not saying we have a constitutional authority to equalize everywhere. I think equality is not the issue. What I'm talking about is corruption in a very specific sense. Not the corruption of individuals engaged in quid pro quo bribery, but the corruption of an institution where members spend 30 to 70% of their time talking to 150,000 people. That's the corruption. Okay, now, in the court's approach to this question of corruption, there are two very different ways to think about it. There's a pragmatic approach, kind of fact-based approach, and there's a purely analytical, conceptual approach. And when Buckley versus Vallejo said, look, there's no reason why Congress should be allowed to restrict independent expenditures, what it said was because there's no present showing that there's any corrupting influence that could come from them. They're not connected to the campaign, so where would it be that and in fact, they could be harmful to the campaign. So there's no reason to be worried about their corrupting influence. But when the court in Citizens United, Justice Kennedy described the very same conception, what he said was, conceptually, there could be no corrupting influence. Almost as a matter of logic, there could be no corrupting influence. And it's that move that I think is just plainly false, because what Evan Bayh was describing, when he was describing the machinations that congressmen go through as they worry about these independent expenditures and how they're going to play, is the way in which they do, in fact, whether conceptually or not, have this corrupting influence because of the increased dependence that it produces on this tiny slice of funders. So to the extent we're arguing about equality, we're not arguing. To the extent we're arguing about corruption, we ought to be precise about the kind of corruption we're arguing about. We're arguing about the systemic effect of a system of funding campaigns where members spend such an enormous amount of their time focused as they are. And I think Congress has the power to address that. Where we agree is that the way Congress addresses that should be the most respectful of free speech possible, which is why I openly endorse public funding as the alternative, as the number one alternative. And Eugene's not in the camp that I've seen that opposes public funding as somehow a violation of the free speech clause. But the only place where I'm willing to consider the need to restrict is to restrict contributions to independent political action committees, which is a category that neither Buckley or Citizens United was thinking about, but which I think is a legitimate category to worry about because of the practicalities as they develop.
This is a question specifically about the implementation of the voucher system. Under the voucher system, this assumes that then any candidate starts to race off with just generally more people who are marginally more in favor of that candidate will receive like much more money. And since you're arguing that campaign reform should happen, then you obviously believe that like money has a very strong effect on campaign, which means the world switches into a world where like that means whoever has like the more marginal support on their side at the start of the campaign has a much higher chance of winning. And obviously you believe this is a better system than what's going on now, but do you believe that's like a very good end game to be heading towards? Do you believe that there's like different political, like there's better systems than this, even if they can't be like implemented at this point?
It's a great question, because I guess I'm genuinely ambivalent about saying let's run campaigns the way the Supreme Court runs arguments. You get an hour and I get an hour. Or you get 30 minutes, I get 30 minutes. I mean, and some countries basically do that. It's the basic structure of the way they approach it. But what I'm saying is we should recognize there are actually 2 elections every election cycle. There's an election that happens on a certain day at a certain time, a discrete election, and there's a continuous election. It happens 24/7 for all the period before that election. The discrete election is when you vote. The continuous election is when you give money. And in seen like that, the problem with our current system is that we've disabled the vast majority of Americans from participating in a relevant way in the continuous election. The South used to have a white primary that excluded blacks from voting in the Democratic primary. We have a green primary that excludes 99.95% of us from voting in the relevant sense in that equivalent primary. What the voucher system does is say, let's include a bunch of people in that ongoing continuous election process. And what it will produce, I agree with Eugene, depending on how it's structured, will produce more people in the political system. I think it's a great thing. I think it's going to be a wonderful thing. Now, I don't want to produce infinite numbers, so I'm perfectly willing to say, we've got to figure out what's the qualification to be allowed to get the vouchers. But if there's some qualification and it turns out there are 3 or 4 candidates in a particular race, I would be totally in favor of that. That'd be wonderful.
I agree with much what Larry says, but just to step back a bit, the fact is, to reach people takes money. Maybe it did so less back in the day when we had what I think of as a low entertainment environment. You couldn't listen to music unless you or your friend produced it yourself. Produced it is to say, actually generated right there on the spot. There were no movies, there was no World of Warcraft, and the question was, do you work on your farm or you go into town in order to hear some debate? I hear about the Lincoln Douglas debates and people sitting there and listening for hours on end to people orate, and I think, well, partly there was maybe different kind of attitudes towards such things, but I think they were molded by the fact that their opportunity costs, as the entertainment opportunity costs, as the economists would like to tell us, are so low. Today they're very high. Today it takes a lot of time and, it takes a lot of money because it takes a lot of airtime and other such things in order to get people's attention. So if you try to eliminate money, you could imagine a situation where nobody can spend money on these things, but then the consequence will be there won't be any real political speech on these subjects. There'll be plenty of speech on things like sports, which people care about, but politics will be a lot less. So I think what I like about Larry's proposal is it harnesses the reality that people aren't terribly interested in paying attention, and in order to get them to pay attention, you have to bring it through media, which costs money to use. And I think that, in a perfect world, we might not have that, but in a perfect world, if men were angels, we would not need government.
Dana?
So I actually went to public school, so forgive me if the quality of my question is a little lacking. But
I did too part of the time, so half my good comments are outside.
But as you stated, voters' attention is somewhat of a limited resource. There's only so many hours a day a voter can watch advertisements. So would you say there's a line between someone's freedom of speech and where that freedom of speech may infringe upon someone with less money's ability to get their voice heard?
No, I don't. I think freedom of speech means the freedom to try to speak to people, spend your resources to try to speak to people. And if the result is that people are so full of what you say, either because they're persuaded or because they're just sick and tired, that they decide not to listen to somebody else, that's an aspect of freedom of speech. One way of thinking about it is that rationale doesn't just apply to elections. You might say there are 2 elections, and I think that's an important insight. In fact, I've heard the term the money primary. used to describe that just by politicos. That's not that wasn't a pejorative. They were just describing reality. But there's also the constant process of people's minds being influenced in a wide range of issues. Gun rights, abortion rights, affirmative action, global warming, you name it. Do the George Soroses of the world have extra influence over that? You bet. Does that translate into political influence? Even if they couldn't have independent expenditures? You bet it would. Should that be a reason to say, well, look, there are already so many ads on with regard to gun rights or with regard to global warming that that's just taking up limited mind share in people's minds. We're just going to restrict those because we feel that that's free speech is somehow infringing on other people's rights to speak and be paid attention to. No, you don't have a right to be paid attention to. You have a right to try to get people to pay attention to you, and that right should not be limited because we're afraid if they pay too much attention to you, they're going to ignore someone else.
Yeah, this actually links to the prior really great question about a fundamental alternative. I mean, I think, again, if you just look practically at the way political campaigns have evolved, there's something enormously depressing about the way in which campaigns do the job they're trying to do, which is to persuade people. Like, you know, I've been involved in the May Day PAC, and I've been watching very closely as, you know, these ads get written to run in these races. You know, I challenge you to sit down and write a 30-second ad that says something, you know, that actually has an idea in it, other than appealing to something grotesque or, negative ads are very easy to write in 30-second chunks. And the point is to just step back a bit and say, wow, we have allowed the system to evolve to a place where the form for engaging is actually not a form that facilitates any meaningful understanding about anything anymore. And other countries can look at this and say, well, that's why the whole system's a bad system. Like, if you had a different way of regulating, not suppressing, but regulating in the sense of a governor regulating, governor on an engine regulating, you might actually have a better opportunity for people to understand what's at stake and a better opportunity to actually advance that. Now, I say that, as a kind of aspiration because, of course, what I'm arguing for would not fundamentally change the way campaigns are run. I'm more and more convinced that's necessary the more I'm involved in running campaigns, but right now that's not what I'm arguing for. What I'm arguing for would just change the influence of the funders, and that's the core slogan, right? The problem is not the speech, the problem is the fundraising. And so if we fix the fundraising, we still have enormous, quote, problems with the way the speech works.
So let me just mention, just not at all to disagree, but just a funny story that I just happened to get in my mailbox this morning. It involves this beautiful city of Providence, Rhode Island. Apparently, I had not known this, there's a law professor running for mayor. Professor Elorza. Pardon?
Lorza.
Jorge Elorza. And he wrote a law review article back 4 years ago. And now apparently, and this may be old news to you, there are now robocalls that are criticizing him, probably in the 30 seconds, for the content of his law review article. Now, my first thought is, wow, they cited his article. How exciting is that? Maybe that doubled the total number of cites it's ever gotten. And I'd say this not to fault him. There are articles of mine that are lucky to get one cite. So that's a negative ad. It could be an example of the folly of the system. Maybe something we can't do anything about. I can't imagine a constitutional rule that bars 30-second ads because we think they're not content filled enough. I don't think it should be for the government to do that. But not having heard the robocall, I very much doubt that it's sort of high quality of really useful input for the public. And hey, if we were all ready just every election cycle to spend several hours watching debates, better debates than we have now, maybe debates like ours. If we were, or to go to town halls or whatever else, maybe the world would be a better place. I'm sure it'll be a better place, but it's not our world.
Thank you.
Yep.
So it seems like the voucher system will kind of put resources and political power in the hands of people who either didn't have it before or had no interest in having it before. How do you avoid a Tammany Hall type situation where people who have no real interest, have this kind of voucher now that they could maybe give away cheaply? It seems like the voucher system kind of presupposes that just by having this voucher, a newfound interest in politics will kind of emerge, which I don't know if I see happening.
Yeah, so it's a great question. First, there are two parts to the answer. One is, When we've done polling around the issue of money in politics, we found overwhelming recognition of the need to fix the problem. So a poll we did at the end of last year found 96% of people believe the influence of money in politics needed to be reduced. That it was important to reduce the influence of money in politics. But 91% thought there was nothing that could be done about it. So, those two numbers together is the politics of resignation. You just accept realities, death, taxes, and a corrupt government. That's just the reality of, especially, I'm not going to say anything about Rhode Island, okay? So, but then the point about the voucher is that if in fact you began to see that there was a way for a different influence to be exercised, then just like the people in Iraq, once they saw Saddam might actually fall, came to the streets to make Saddam fall, there's a chance that that thaws the resignation and people come out and try to do something about it. And then the second part is about the practicalities of it. Yeah, it's a really important concern that people don't engage in voucher buying. Just like for most of, up to through the 19th century, they engaged in vote buying. Some areas, 25 to 40% of the votes were purchased. And they could be purchased because of the mechanism of voting back then, which was public. You went into a space, you raised your hand, and you said, I vote for this candidate. You raised a card, I vote for this candidate, I vote for that candidate, which meant that contracts were easily enforced. Because I say, I promise to vote for your candidate, you observe me, there's a deal, so now you're going to pay me for my vote. The secret ballot comes in, and it didn't eliminate vote buying, it just lowered the value of a vote to be sold, because if you're the kind of guy who's going to sell your vote, you're also the kind of guy who's like to sell your vote twice or 3 times, which means you're not a reliable guy to buy a vote from. Now the same thing can be done to the voucher. The way to avoid voucher buying is to say that any transfer of a voucher to a candidate can be revoked within 24 hours. Okay, so I say to you, if you give me $10, I'll give $50 to your candidate. So you give me $10, I give $50 to your candidate, then 24 hours later I get it back, and then I give $50 to his candidate, and then $50 to another candidate, and you know that. So you're likely to say to me, if he's the sort of guy willing to sell his voucher, he's the sort of guy willing to sell his voucher 3 times, so the value that you're going to place in the voucher will be pretty low. So just like vote buying, we could have voucher buying, but I think we can regulate it so it's not actually systemically something that accounts for how the vouchers are being allocated.
Thank you.
I was wondering if you guys could go back to the corruption issue you were talking about before, and sort of in conjunction with unequal access. Professor Volokh specifically, I was wondering if you could explain why, or if you actually disagree with Professor Lessig on whether or not there's corruption in unequal access.
I wouldn't label unequal access corruption as such.
Right.
I agree there's unequal access. I agree that in many ways it's bad. I agree that the unequal access can produce what everybody agrees that is corruption, which is essentially, if you want my support, you've got to fund this private project or this project that's going to make me money. That is, I agree that all of that is present. I think it's present, as I mentioned in the example of the newspaper publisher. Now, it used to be actually, as I said, the newspaper publishers were tremendously
So
important.
you agree it's present, but you disagree that we should do anything about it?
Well, it's kind of like, do I think there's a problem with, say, racist advocacy? Or do I think there's a problem with violent rap lyrics? I'm actually not positive about violent rap lyrics, but there's a plausible argument to be made for the proposition that when people sing songs that glorify violence, even when they say, no, this is just art, this isn't really real, some people, especially impressionable youngsters, are going to act based on that. There's a second question, not are we going to do anything about it, is are we going to restrict speech in order to do this? So is there a problem with the newspaper publisher having the ear of the candidate or the elected official in a way much more than any of us on equal access, and in a way that he can use to his own private advantage? Potential quid pro quo corruption. Yes, there's a problem. Are we going to say, therefore, newspapers can't editorialize, and we're going to have a newspaper slant review board in order to make sure that they don't subtly slant this? No, we won't do that. It's not like there's nothing that we shouldn't do anything about it. Actually, I think Larry's proposal might be an interesting way of trying to do something about some aspects of it. But the fact that there's a problem out there, with that some speech can pose some problems, no, I don't think that's a reason enough by itself to restrict that speech. And often, yes, we suffer through the costs of the speech rather than restricting speech.
So let me go at this a different way, because I think is a pretty fundamental point that I haven't made clearly enough. I don't care about unequal access. I care about improper dependence. Right? So let's think about a category of democracies we could call Tweedist democracies, after Boss Tweed. So Boss Tweed had a famous saying. He said, "I don't care who does the electin, as long as I get to do the nominating." Okay, so Hong Kong recently announced that their governor is going to be, they promised 10 years ago their governor would be elected by an election in 2017. That would, from then on, the governor would be chosen, the chief executive would be chosen by an election. But at the end of August, they announced that the governor would be nominated by 1,200 people in a council. And that council, it turns out, represents business interests in China. So people in China say, well, wait a minute, this isn't democracy because you're basically picking the candidate from these kind of business interests. 0.024% of Hong Kong gets to pick the business interest. And so that's a kind of Tweedist democracy because the first stage is controlled, the nominating is controlled by something that's not in any sense representative. And that's the same thing with Iran, that's the same thing with the Soviet Union, that's the same thing with white primaries, that's the same thing with the green primary. That's the structure that we've created, Tweedist democracy. Okay? Now, what I'm against is the improper dependence that puts into the system. And when you have an improper dependence, that is what our framers, at least, used to refer to as corruption. When they talked about the corruption of parliament, they weren't talking about parliamentarians engaging in bribery. They were talking about the king having an improper influence inside of parliament because he got to pick, essentially, a number of members of parliament, an improper dependence. And we have that same sense when we talk about the judiciary. Look, it said, my colleague at Harvard, Mark Ramsayer, has done incredible work to demonstrate a kind of improper dependence in the Japanese judiciary. So basically, in the independent judiciary of Japan, you only get promoted to the right kind of jobs if you consistently vote for the government. So if you vote against the government, you find yourself on some remote island. And if you vote for the government, then you find yourself promoted. Well, from our conception, that's a corruption of an independent judiciary, because the judiciary is supposed to be dependent on the law, not dependent upon the continued political favor of the government. So what I'm criticizing is the wrong influence inside of this system. And I'm talking about remedies to that wrong influence, some of which Eugene's perfectly okay with. Think about the way money, public funding might be a way to be that kind of remedy. But even in my utopia, there's going to be inequality. There's going to be inequality in access. People are going to have different kinds of inequality. It's just, in my view, it is less debilitating to the democracy if we have an opportunity through things like vouchers and something to aggregate the influence necessary to affect democratic policy.
My question kind of follows up on that point, and it's directly for Professor Lessig. I find your argument very, very compelling, but I'm still, some of the points Professor Volokh raises leaves me searching for the limiting principle there, because I think you've done a good job of shifting away from the limiting principle argument, because a lot of times people will say, well, if it's speech, if money is speech, well then why isn't everything else? And you've done a good job by focusing on the influence and the corruption, I feel like, but isn't if it's influence, isn't that just moving the ball a little bit, not really getting at the source of the tension? Because as some of the examples that Professor Volokh raised, still, if you regulate it here with money to super PACs, well, why is it just that? Why should we stop the regulation there when, if we do that, it's likely that, Ben Affleck or a media organization or the Sierra Club will influence some of the same type of influence that could bring about the same type of corruption that you're trying to go about solving?
Right. Great question. First of all, the main problem to solve has nothing to do with the Supreme Court. The main problem to solve is the way we fund elections. And the Supreme Court has nothing to do with that. We have to get Congress to pass laws that change the way we fund elections. And that's the core pro-speech reform that we've got to push for, and that's the sort of reform that I primarily push for. And I think that we are mistaken in obsessing about the Supreme Court's construction of some kind of bad democracy. Look, Citizens United, I have all sorts of problems with Citizens United, but even if you think that it shot the body of our democracy, the body was already cold when it shot it, because we had already produced a system where the tiniest fraction of the 1% had this influence because of the dependence Congress had on them. So I want to solve the core problem by changing the way we fund elections. And then I want to think not analytically or conceptually about different ways in which we might have a corrupting influence, but very practically about different ways we might have a kind of corrupting influence. So I point to super PACs as having this kind of corrupting influence because of the dynamic which everybody inside of Washington recognizes they've produced in capturing the attention and steering members of Congress because of their potential and enormous influence. Like Jack Abramoff has this wonderful quote in his book where he describes the most important technique that he had as a lobbyist. He said the most important technique was I would go into an office and I would meet with the chief of staff and I'd say, so what are you doing in 2 years? And the chief of staff would say, I don't know, Jack. And Abramoff would say, okay, I want you to look me up. And Abramoff says, from that moment on, I owned that staffer and not a single dollar had changed hands, right? And that begins to give you an insight into the practical way in which the influence there was being exercised. And what I'm saying is if you look at the way super PACs actually practically interfere, they're creating the kind of dependence that I think is the improper dependence because it's such a tiny, tiny slice of people that have that dependence, which again explains why I don't have any problem with aggregating money as long as the facility for aggregating doesn't replicate this radical disconnect between lots of people getting together and 5 people getting together. Rahm Emanuel in Chicago has a super PAC. Basically, 5 billionaires have funded it. That super PAC will dominate the elections in Chicago for as long as Rahm is mayor. The problem with that is not that there's people speaking, it's that this tiny, tiny number have that kind of power, and that's what I think is the dependence corruption that we produce.
Speaking of unequal access, I think
Yeah.
that microphone hasn't been getting much use.
Thank you. Professors, thank you for both spending your time here. We all appreciate what you've done so far. My question was, the America that I always grew up was always that each individual's vote mattered. And I was always curious, how come we can't have equal access? Why not just say that, so it's more fair for everybody that an individual can only give, that only individuals can give to political campaigns, but that the limit would be, like, say, something that everybody, so there's some number that people that are very rich and also people very poor, let's say something simple like half of what a politician's salary is that they're running for. They can receive that up to that amount of money each election cycle. So you keep it capped at a certain number that is much more easier for the rich to be able to give. It also limits it. Cause I always look at it as speech can be limited because we always said that you can't say fire in a crowded theater. Why not say that speech is money, and like what has been saying that why can't that also be limited?
There are a lot of things going on there. Let me try to go through them one at a time. One is, people who talk about free speech, and actually people talk about other things. Abortion rights is a classic example, gun rights and various other things. Talk a lot about slippery slopes, and some people poo-poo that. I actually wrote an article, 100 pages, which, speaking of how too much speech might actually diminish the value of it, all about slippery slopes, and I think they're very real. And here's one example. Back in 1919, Oliver Wendell Holmes said all the protection of free speech won't justify won't justify blocking the government from punishing someone for falsely shouting fire in a crowded theater. That was a very simple explanation for a very narrow exception. To be sure, Holmes himself, unfortunately, in that case, didn't take a very broad view of free speech, although he quickly moved to that. Very narrow exception. Falsely shouting fire in a crowded theater, very little value in false, especially usually knowingly false speech. Shouting fire in a crowded theater, well, it can cause imminent deaths of tens or hundreds of people. In fact, that had been what had happened in theaters, which had the film that burned very quickly, and the theaters themselves in the decades before. Everybody understood that this was a reference to very real phenomena. The people who worry about slippery slopes, so okay, you start with this narrow exception, and what is it going to lead to? And now we're seeing it being used as an argument, and I'm not just talking about this particular question, I hear it all the time. The falsely gets conveniently dropped. The consequence is, well, any kind of speech that we think dangerous enough can be restricted, because, well, after all, you can't shout fire in a crowded theater. I think if this narrow an exception can be used as a basis for much broader exceptions. One thing we might ask ourselves is, once we say, well, now we're going to have a broader exception for speech that unduly influences the political process, how much more will that lead, or how many more and broader still restrictions we will slip to from there? So that's one particular point. So a point about a particular rhetorical argument, but I think it's an important one. Now, a second point has to do with contributions. I agree that contributions to candidates should be, by individuals, should be limited and can be limited and are limited. So we're talking here not just about contributions to a candidate, but contributions to speech about the candidate. That's just an important point. You could argue in favor of such restrictions, but I just want to stress that. A third point is, I heard an argument there about restricting the total amount that can be spent by a candidate. Since I assume you're not saying you can contribute up, each person, each of us can contribute up to half of the salary of the candidate, because after all, that would vastly, like 50-fold probably increase the, or maybe 30-fold increase the caps that are there. That would be a limit on the total amount of spending by the candidate. Well, look, senators, and in California, which is a bigger state than Rhode Island, though it's an issue even in Rhode Island, senators, I think, get less than $200,000 a year. Try running a Senate campaign on $100,000 a year. If we had this cap, the Supreme Court struck down those caps, but you can imagine the Supreme Court saying, well, if you're running for government office, we're entitled to impose restrictions on you. We can't on private parties. The consequence would just simply be there wouldn't be viable political campaigns because there would be no way for somebody to run a campaign in California on $100,000. But that's a separate matter what third parties do. And then finally, this question about, well, shouldn't every vote matter? I take what it means every vote should matter equally. Literally, every vote probably doesn't matter just because of the realities of the large numbers involved, but shouldn't every vote matter equally? Well, yes, but again, I return to the examples that I gave. In a perfect world, wouldn't the publisher of a newspaper have no more influence over the political process than you or I? Maybe, if all we cared about, what we most cared about was equality. Is that reason to restrict what the publisher of the newspaper can do, and the amount that the publisher could spend on buying a newspaper if what he really wants to do is change the political complexion of the debate? I think the answer is no, and I think the answer is no to people who want to buy not newspapers, but buy individual instances of speech.
Although I would say, in agreeing with the framework you've offered, if you accept the way I've described that we live in basically a system of two elections, one is a voting election where you're supposed to go out and vote by casting a ballot, and the other is the funding election or the green primary where you're supposed to be giving money, there is something fundamentally wrong with a system that denies the equal citizenship of members of this public by effectively discounting the contribution or the relevance of 99% of the citizens. That's not about equality of speech, it's about equality in the relevance of your participation. Now, you're right, there's going to be lots of districts where all voters aren't actually going to be fundamentally equal because, Utah doesn't matter as much as a contested state like Ohio does in presidential elections, for example. But what we can say about the current system is that in this critical primary, the green primary, 99.9% of us don't matter. And our views don't matter. And in my view, anytime you set up a system, this Boss Tweed-like system where you've allocated such enormous influence in a way that doesn't reflect anything of the commitment to equal citizenship, you violate the principle of equal citizenship, which I think is at the core of any republic, representative democracy.
Thank you for your time.
So unfortunately, we have to wrap, so this will be the last question. We'll be outside for a little while, so if you like, you can come outside and ask your question directly outside.
Okay, my name's McCutcheon. I'm a professor in sociology, and actually Larry Lessig and I went to law school together, so every time I see him, I'm impressed by how I've wasted my life, or at least wasted my life making bad PowerPoint, because his is so much better. But a couple of things. First of all, my general take is that the situation may be bad enough that we need an all of the above solution or something close to at least several of the above. And so, I think vouchers are not a bad idea because they at least somewhat chip away at inequality. And it seems to me that in today's America, everything that we can do to chip away at inequality is probably a plus. I think that public funding of elections is a good idea because it goes after the dependency a little bit more directly, at least reduces the proportion of the spending for which people are dependent on individual donors. And I think there might be something to be said for some kind of time, place, and manner restrictions on speech at the very near term to an election. The last week, the last 30 days, to take the Biden example, we don't allow people to go down the street in the middle of the night with megaphones. A super PAC is a kind of a megaphone. A robocall is a kind of a megaphone. And it's not clear to me that there would be a huge risk of a slippery slope if we at least thought about what those megaphones were and when they were appropriate and when they weren't. So, in some sense, all of the above. I will also say, though, that when I get depressed about campaign financing, and I will say this since we're at the end and should leave on some positive note, it does strike me that if we look at what period in history the American polity did the most aggressive job of going after concentrated wealth, it was during the Progressive era, when there were not campaign financing limits, to the best of my knowledge, at least. There weren't many. There were some clean government laws put into place, but that was more a consequence than a cause. And what was really happening was that there was a lot of grassroots mobilizing in the labor movement and in various other kinds of bodies. There was a lot of active mind share going to inequality and how to address it. And power to you for wrestling with the campaign finance issue, but I actually think that one shouldn't be depressed by the state of affairs, that there may also be other levers to address some of the consequences.
Well, I'm not depressed. I'm optimistic for exactly the analogy that you've drawn. The incredibly important thing about the progressive era to remember is that progressives were not all liberals. Indeed, some of the things progressives talked about would be the things that embarrass liberals today, like eugenics was a progressive idea. But the thing that united them was a recognition that the government had become fundamentally corrupted by the way in which business interests had infected the system. And on that ground, you had strong Republicans, Teddy Roosevelt being the most famous, but not the only, who kind of led a charge that said, we've got to find a way to restore a sense that a democracy is reflecting what the people think it should reflect, because if we don't, none of these other things that we want will ever be possible. And I think we're increasingly coming to that point now. There's a famous story in Mike Lux's book about the Clinton administration, where he describes in the beginning of the Clinton administration, there was a debate. Should they pursue campaign finance reform or should they pursue health care? And the decision was to pursue health care. Now, in 1993, I'm not sure that was the wrong decision, because in 1993, I don't think the system had become as terrible as it's become now. But I think increasingly people are recognizing that regardless of what you care about, there is no way to get sane policy on that issue, whether it's on the left or the right, given the current way in which we fund campaigns. That's because we've produced, as Francis Fukuyama has put it, a veto-ocracy. It's not a kleptocracy or an aristocracy or a plutocracy. It's a veto-ocracy. And what he means by that is it's trivially simple now to veto almost any kind of reform on either side because of the dependence that's been built to funding on top of a constitutional system that already had checks and balances that made it hard to get anything done. And so I think if people recognize that regardless of your issue, healthcare, the debt, climate change legislation, financial reform, equality issues as it relates to income, regardless of your issue, we will not make any progress until we make progress on this issue. That's the birth, that's the genesis of the progressive recognition that actually fueled the movement that got us to the place, and quite successfully. Look at incredible Zephyr Teachout in New York, who, with no money, literally she had, I think, $400,000 against Governor Cuomo, who had $30 million in that race, ran a campaign about the corrupting influence of money and the corruption of the system against the anti-corruption governor who corrupted his own anti-corruption commission to protect himself from criticism while it was criticizing other people on the other side. She got 37% of the vote in a primary in New York with no money, because this issue is salient, increasingly salient, in a way that I think gives me incredible hope that there's a way to get to the right solution.
I'm always pleased by optimism because by nature, I think I'm an optimistic person. I think a lot of the problems that Larry identifies are quite real problems. I hope there's a solution. I want to return to them in a moment, but first, just being a law professor, I want to just lay out a couple of things. First, when the court has said the time, place, manner restrictions, such as bans on sound trucks, for example, are constitutional, it has always said when they're content neutral. So if you were to say no sound trucks, constitutional. If you were to say no sound trucks that express support or opposition to candidates, unconstitutional. Maybe your proposal could be justified under whatever rationale, but to the extent that people might say, oh, time, place, and manner, oh, well, there's this whole body of case law out there supporting that. No, that body of case law, the time, place, and manner case law, would render that unconstitutional because it stresses that content-based restrictions are impermissible even if they just limit the time. And incidentally, limit the time not just, well, you can't do it in the middle of the night when all you'll be doing is waking people up, but you can't do it in the time when the advocacy is most important and when people are often actually making up their minds. A second point, just, it's a historical detail, maybe the court got it wrong. A very similar argument was made, I believe in Alabama, when the Alabama legislature banned editorials for or against political candidates, very, very close, in newspapers on election day. The theory being that this didn't give people enough opportunity to rebut whatever charges there were. Mills v. Alabama, I think it was Mills v. Alabama. In Florida, Miami Herald, also an important case. In Mills v. Alabama, the Warren Court, I believe, unanimously struck that down. Again, maybe they got it wrong, or maybe newspapers should have the right to do this, but other people shouldn't. But just to keep in mind that to the extent that there's some wisdom in the court's case law, it seems to cut in the opposite direction. But let me just close about what I really, really like about Larry's proposal. There's some parts of it I disagree with, but much of it, what's it trying to do? It's trying to do what the progressives, at their best, also tried to do, and there's much that I disagree with the progressives, but they were trying to fight the problem of political corruption with ways other than by suppressing speech. It's often very easy to say, look, there's this speech out there that I dislike. I think it's dangerous. I think it's so dangerous I'm going to conclude that it's kind of like falsely shouting fire in a crowded theater. And the way to reach the results, the way to reach the beautiful country that I want, is by suppressing this speech that I think poses these dangers. That's not what the progressives did. It's that. To be sure, progressives did that. Woodrow Wilson, a classic example of a progressive in the Democratic side, was the one who I think helped push through. Of course, Congress enacted it, but it was during his administration and with his blessing, the Sedition Act of 1917, or the Espionage Act and the Sedition Act, I think, of 1917, which banned anti-war advocacy, which in fact was upheld by the court by analogy to falsely shouting fire in a crowded theater. The theory was, in order to have the war effort that we need, in order to protect the lives of our boys out there, it's not enough that the government argue in favor of the war. We have to suppress people whose views we think are going to help bring about these very bad effects. That was not, I think, an example of the glory days of progressives. So what I really like about Larry's proposal is, I think he deals with a very important problem, which I agree is in many ways a very important problem, and he tries to come up with a way that, and again, I may disagree with small parts of it, but on balance, is a way of solving the problem without restricting people's ability to speak out, whether they're newspaper publishers, or whether they're celebrities, or union leaders, or anybody else, to speak out even in ways that might have some possible harmful consequences, but nonetheless should be protected exercise of their free speech.
All right, let's give our speakers a round of... Thank you all for coming. I think there are refreshments outside, so help yourself.